Hi, it's Daniel at Stidham Financial, back again with another frequently asked question. And because we are a fully integrated network of professionals, when we get questions, there's not always one answer. There will be a financial answer, there will be a legal answer, there will be many other answers, and then there will be a big picture answer. So today's question is one of those. One of the most frequently asked questions that I get is, why do I need a power of attorney for my spouse? They're my spouse. They should be able to do anything that they want to do with my accounts. Well, should means nothing. It's whether or not they can. Many people assume that because you're married, your spouse has the right to access your accounts if need be, such as you're in a care facility or you're unconscious. However, that's simply not the case. If you have investment accounts, if you have IRAs, if you have 401ks, or even bank accounts that are in your name solely, regardless of the circumstances, unless you have a durable power of attorney, the financial institution will not even speak to your spouse. But that's just from the financial perspective. So I have Mr. Nick Corey here with me today, who is an estate planning and a tax attorney, who's going to walk us through a couple more. Nick?
Powers of attorney can come in several different flavors, and the majority of the difference is when they turn on and when they turn off. If a power of attorney, say a client is nervous about giving his or her spouse unrestricted access to any and all financial accounts, they can opt for a springing power of attorney. And the only way that becomes effective, or actually turns on, is upon a declaration of incompetency by one or two medical doctors. So if someone were to go into a coma, the doctor could sign off that yes, this person is indeed incompetent, and now the springing part of the power of attorney has sprung, so it's now effective. The other end of the spectrum is when the power of attorney turns on or off based on incapacity. For a power of attorney to be effective, the person signing it must have capacity at the moment they sign it. A regular power of attorney turns off and becomes ineffective if that person loses capacity to sign it again. So if it doesn't have a durability provision in it, if that person becomes incapacitated, the power of attorney is no longer effective. But Arkansas law allows for durable powers of attorney, which simply means that they remain effective after a declaration of incapacity.
So in the end, it really comes down to which is right for you. I recommend these for the financial reasons in most circumstances for my clients. But as Nick said, they come in many different flavors, and you need to consult a professional to find out which one is yours. Please email us if you have any questions for Stidham Financial at info@stidhamfinancial.com.